All right. Good morning, everybody. My name is Brad Williams. I am with the Public Policy and Business Advocacy team here at the Detroit Regional Chamber. And I would like to say I'm glad you're here, but I know that all of you are here because you are going through a really stressful time as an employer. This has been a hectic and stressful time for a lot of folks, ever since the Supreme Court put the Earned Sick Time Act into effect, which we all know is going to happen on February 21st, minus action from the legislature. Um, as people are preparing and getting ready for potential implementation of this act at the chamber, we knew that our members had a lot of questions about how this is going to impact them, how they should implement this for the benefit of their employees. And so we're very lucky today. We have Sean Egan, who's the Deputy Director for Labor at the Department of Labor and Economic Opportunity with the state, who's charged with implementing the Earned Sick Time Act. And let me tell you about Sean. We first met Sean at the beginning of COVID. And he has been an invaluable resource to us at the chamber and the business community and helping us navigate these unprecedented times that we have seen over the last 5 or 6 years. Not just in the background by answering the questions of people like me, but Sean's been participating in webinars like this for the chamber and other organizations I know as well. Just a moment of housekeeping before we get into the meat of this presentation. I want you to know if you have a question, there is a Q&A function at the top of your Teams link. Please use that for questions that you have for Sean. I'm going to be monitoring that throughout the balance of this morning, and I know there's going to be a lot of questions. I will do everything I can to make sure that we can get to as many questions as possible. And it may mean that I group some of your questions together. So if the other thing you should know is if you don't get your question answered, we are collecting them. We have your email address, and we will do our best to get your questions answered at a future time, even if we can't get them answered today. If you're having technical issues with this chat or this presentation, there is the chat function. My colleagues Elizabeth and Jeff are monitoring that. I know I already saw someone is having trouble with their audio. No one's ever had trouble hearing with me. The volume of my voice is something that's been commented on multiple times. Well, let me tell you about how we got here. Earlier last year, the Supreme Court ruled that the Earned Sick Time Act, which was a citizens initiative, as well as an initiative to raise the minimum wage for all workers, including servers, needed to go into effect because the legislature had amended it unconstitutionally. At the chamber, we disagree with that decision, but that doesn't change the fact that the Supreme Court made the decision and we have to live with it. The House of Representatives just last week passed a bill that would get us in a much better place with the Earned Sick Time Act, House Bill 4002. It's in the state Senate. I would encourage you to go to senate.michigan.gov, look up your state senator and call them and ask them to pass Senate Bill 4002. There's 5 things in there that we are hoping to get done in Senate Bill 4002. First of all, to allow you as an employer, if you have a more generous plan like PTO, to keep that plan and not have to take that away from your employees because you offer them earned sick time. 2, and Sean will talk about this a little bit earlier, is allow you to front load the hours in advance. Rather than earning them as they are loading them as they accrue them. Third is creating an exemption for small businesses. This is something for those of you who are small businesses, I know is additionally stressful because you don't have the back end support to put this in place. Fourth is changing the policy that would allow an employee to do what we call a no-show, no-call. for 3 days and making that a workable policy for employers. And fifth, but not last, is getting rid of a rebuttable presumption that would give employees a private right of action if the Earned Sick Time Act was violated. And I will say, if we can get the first four done, the fifth one becomes less urgent. With that, I've just about run out of my time for introduction, but I do want to make sure we welcome Sean. Like I said, he's the Deputy Director of Labor at LEO, the Department of Labor and Economic Opportunity. He has a wealth of knowledge on this subject and many others. I know there's some questions that he might not be able to answer because of the complicated nature of this issue. But he's going to do his best, and Sean is the expert on this issue. So, Sean, thank you for being here. Thank you all for joining us, and I'm going to let you take it away, and I am going to monitor the Q&A portion and try and get as many as possible.
Awesome. Thanks so much, Brad. I think certainly happy to be here with the Detroit Regional Chamber, and we've been around the state trying to talk about this. As Brad said, we are the regulatory arm that would oversee ESTA and its implementation. So we are doing our best to try to answer questions. For many of you, as Brad talked about legislative changes, that's not really our bailiwick. So we're going to talk to you as the law currently exists. And then certainly we kind of joke that you may see me in about 2 weeks talking about the updates if that happens. So we're happy to do outreach and always try to be available to do our best to answer questions and make sure that we're sharing as much information as we can. I'm going to run through a quick slideshow, but the goal is really to get to your questions. So I'll try to be as brief as possible and make sure that you have a chance to get through as many questions as possible. And if you'll indulge me for just 2 minutes, I'm going to run through a very quick update on minimum wage. I know we're here to talk about ESTA, but just want to share some of the information that you're going to need to be aware of. As you know, on January 1, we had an increase in minimum wage of about 23 cents based on the existing law. And then because of the Supreme Court decision, the updated minimum wage goes into effect on February 21. So you will see a change there to $12.48 as everything currently stands on February 1st. And there's a change in the minimum wage for tipped workers that use the tip credit to 48% of the minimum wage to $5.99 an hour. And we all know that kind of goes over time. I'll skip the history of the tip credit, but generally in Michigan, employers are allowed to take a credit for tips received by the worker, but they have to pay at least that 38% of the minimum wage. So depending on where you are, that first $6 or so of tips is really offsetting the employer's obligation to pay the full minimum wage. They're still on the hook for the full minimum wage. And if the tips don't meet that, the employer is obligated to make up the difference. And then a couple of data points I'll have for you just to kind of show, and I just want to share because, depending on what side of these issues you're on, some people want to keep it same, some people want it more progressive, some people don't understand why things aren't changing faster. And some of the data is just kind of hard to filter through. So that yellow bar somewhere in the middle there, you'll see Michigan's at about 393. This was before this update in January of the absolute minimum that tipped workers receive. We're kind of in the middle of the pack. Most of those states on the right there are at the federal minimum wage, which is $2.13. And then that top line was a study in April published in the USA Today, but came out of another group on credit card receipts and evaluating tips in different states. And you kind of see it kind of bounce around that 20% line. Everybody is very, very similar. So some of the information is hard to decipher. And then BLS data kind of just shows earnings by state, and those states that have a higher tipped minimum, workers tend to make more. So it's, just a challenging issue. And then similarly on earned sick time, just real quick, using BLS data, this is access to benefits based on earnings. So it's a little hard for their data, but that lowest 10% there is somewhere around $30,000 a year, and that highest 10% somewhere around $110,000 a year or more. And earned sick time in and of itself is both family and sick leave. So when you look at these two kind of bar graphs here, in the family space, less than half of all workers have access to what they would consider family leave. And then in the sick space, we do see a lot of coverage for earned sick time or sick time benefits, but it definitely decreases by wage. So on the lower end of the income, less than half are likely to have access to those types of benefits. So legislators are kind of looking at this through different lenses, but that's one of the challenges. So earned sick time, as you all know, you've been seeing in the news, you're following along, February 21, 2025 goes back into effect. And current employees and new employees on or after that date will begin accruing sick time. And there really are no exemptions in this law as there were in the Paid Medical Leave Act for those that were familiar with that, except we did find one federal preemption issue for railway workers that are covered by the Railway Unemployment Insurance Act. So I don't know if we have any railway companies with us today, but there is an exemption for those because that federal law specifically talks about sick leave benefits, and courts across the country have found that they are preempted, but we have not identified any others that would fall under any kind of federal preemption. Certainly, you all know it's full-time, part-time, salaried, hourly, you name it, that are going to be covered by the law. So there, again, are no exemptions in this law. You accrue 1 hour of sick leave for every 30 hours worked. One of the things that we do want to point out to you is that there is no connection in this law between 30 hours and a pay period. So presumably the employee earns that 1 hour as soon as they hit 30. So I work 40 hours a week. Thursday afternoon-ish, I'm hitting my 30 hours. I have 1 hour that has become available as soon as I need it in that week if I choose to use it. So I know that is a challenge. We've talked with a lot of employers about that, but the way the law is written, there's no connection to pay periods or anything else. It's as soon as you hit 30. Also, conversely, there is nothing in the law about proration. So if I work 40 hours a week, that's something like 1.23 or whatever, right? Hours that I would accrue. You don't necessarily have to count it that way. It's actually every time the worker hits 30. So in that next week, when I get to 60, now I have 2, and then, so on and so forth. There's nothing that says you can't prorate it, but just pointing out that there's no connection to pay periods and there's no necessarily prorating there. There are some differences between, in the current law, between the amount of paid time for big and small employers, and it's fewer than 10 or 10 or more. So if you fall in that category, I'm happy to answer that question, but I won't spend too much time on it. In either case, the employee is going to accrue up to 72 hours in that year or more, and I'll get to why it's or more. But if you're small, it's 40 paid, 32 unpaid, and all that kind of stuff. But happy to get into more detail in that if we need to. For the purposes of employee counts, it's employees nationwide. So presumably you could understand that the goal of that language is not to exempt something like Microsoft that might only have 9 employees in Michigan from the full 72 hours. It's really intended to get to those smaller employers. Here's where we get into some challenges. And when I get into FAQs about front loading, we'll start to explain. The 72 hours as described in the law is a limit that the employers can set. It's not a limit on the accrual for the employee. You can allow employees to use all the time that they accrued, and the drafters contacted us after the decision too and said that that was their intent, was to allow the employers to set that limit, but encourage employers to use it all. That's your call. The law says that the employer can set the limit, and they can carry over basically an unlimited amount of time from year to year, year to year, year to year, the way the law is currently written. And as Brad pointed out, within the law, there's currently a private right of action and some rebuttable presumption stuff. I already covered that. A couple of quick points that we've been getting a lot of questions about is publicly elected officials or members of boards and commissions in local municipalities or otherwise. Generally, elected officials will not meet the definition of an employee, so they would be exempted. The same is true for many appointed boards and commissions. We like to use that everybody's favorite government word where we say generally. And the reason we say generally is because different cities or townships might do something different. So you could be like an elected drain commissioner often is a full-time employee, so they would be covered, where an elected supervisor might get a stipend for coming in twice a week or something like that, but they're not really under the control because they are the control of that entity, so they're not going to meet the definition of an employee. So I won't spend any more time on that, but I know it gets a little bit interesting. One final note on that small employer piece is that the way the law is written is that If you're 9 or fewer and you hire a couple of employees for the summer or whatever else over a certain number of time, period of time, as soon as you hit 10 or more, you're considered a large employer for this law for the remainder of the 12-month period that you've selected, as well as the next one. So for employers that are relatively small but kind of bump up here and there, you'll want to be mindful that once you hit that kind of 10 or more, you stay in that for the remainder of the 12 months and then the following calendar year. So again, if you choose to limit, and that, we keep saying it that way because it is up to the employer, you can front load these benefits. But the reason that Brad is and other in the business community are pursuing a modification here is to make it very, very clear, because there is no connection between the 72-hour limit and accruals in the law as written. So from a regulatory perspective, you have to allow the employees to carry over additional accrued time from year to year, whether or not you set that. If you set that 72-hour limit, they may not be able to access those benefits. The law doesn't really, as written, doesn't care. So presumably for me, if I work overtime, if you did the math, you got to work more than 40 hours a week to get to 72 anyway. But for those on the call who have people that work overtime, they're going to accrue hours in excess of 72. They're going to be able to carry those hours over indefinitely. So it creates a real challenge for us too, because it's a little bit peculiar, right? That if you set the 72-hour limit and somebody's carrying over 100 hours that they can never use, if they filed a complaint and said, you didn't carry over my hours, we would actually have to probably still find a violation of the act. Doesn't mean we're going to do anything about it, but it technically it would be a violation of the act if you're not allowing that carryover. So we do believe you can front load, but we kind of say you're probably still going to want to check those hours at least annually to verify that you're carrying over the correct amount of unused earned sick time benefits. And I know it's complicated and convoluted, but we have to go by the way it's written, not the way that seems more practical. And that's kind of where it is right now. I won't get too deep into the reasons you can use it, as you've all been reading that. But if you're covered by FMLA right now, the easiest way to sort of think about it is it's basically like paid FMLA for that, whatever those hours are, 72 hours, let's say, for sake of discussion. Plus, there's a couple of in there. So under FMLA, having a cold or the flu is not a serious health condition. Under earned sick time, that would work, right? That would be enough for the employee to be able to use that time. They have a little bit more access to family, and then notably for child care reasons. So if your child has behavioral issues and you're meeting at the school, they can use this time for that meeting. It is not for meetings with the basketball team or something like that. It's for, I have to go to school because we need an IEP, or my child is having behavioral issues in the class that we need to address, or something like that. But they can use that time for this. And then there sort of is a catch-all on if the place of business is closed for a public health emergency or it's order of a public official. I kind of liken this to what we experienced during COVID, where we had public health orders saying that schools couldn't be open or certain places couldn't be open. Theoretically, the employees could use this time for that. But here's a big question, and Brad brought it up, and I'm sure we'll have some more in the Q&A box, but the notice provisions under the Act as they currently exist. So if you have foreseeable leave, I have my doctor's appointment next Tuesday, you can require 7 days advance notice. If that doesn't happen, the employee is not in compliance. They can likely still use the time, but you would be able to use your policies and procedures to do whatever it is you need to do in your workplace. The bigger question, of course, is this as soon as practical. So this has been defined in the Family Medical Leave Act since the foundation. It's the same language there for foreseeable versus not foreseeable leave that employees might need that are covered by FMLA. It is also in the federal contractor requirements that require you to provide earned sick time or paid sick leave, as they call it, where it's as soon as practical for unforeseeable leave. So this has been defined, probably not as clear as Brad would like, but it has been defined throughout time. And in the example the FMLA uses that we've also borrowed and used for consistency is your child has asthma, severe asthma. They have an asthma attack. You're rushing to the emergency room and doing whatever it is you need to do to take care of your child. You're not going to be expected to stop and make that phone call while you're in sort of the rush of getting the child taken care of. But as soon as they're stabilized, you can be expected to step out and call the employer and let them know that you need this leave. And if they don't do those types of things, you could apply discipline for not meeting that requirement for as soon as practical. Now, that's going to create a lot of challenges for you and for us, because that's where a lot of arguments going to be, right? That I notified them as soon as it was possible. The concept of 3 days no call, no show is not really feasible under this language. The individual would have to be incapacitated, in essence, to prove that they didn't have the opportunity to call the employer at any time during that 3-day period. Certainly possible. Same would be true under FMLA. They would, in essence, have to be incapacitated in a way that they didn't have an opportunity to notify the employer that they needed the leave. So I know we've talked a lot about that in the media, and we've talked about that with different business groups. It's not quite as broad as what you think, but it certainly is not as clear as what you would like, I would imagine. So we understand that, but that it's not, this phrasing has been defined through FMLA disputes and case law and everything else to kind of narrow the scope of what as soon as practical means. And it's as soon as that break in the action occurs. Under the laws currently written too, is that the employer cannot require documentation of the need for leave until 3 or more consecutive days. This is very similar to FMLA as well. It's got to be, relatively vague and all that kind of stuff. Like the doctor signs off on it, but they don't get to tell you like Sean has whatever, right? It's just Sean needed the leave is kind of what you get to. The same is true for the domestic violence safe leave provisions and things like that. And you can't delay the use of the leave until the documentation shows up. And then notably, actually, we took that off. Under the laws currently written too, is that if the employer requires that documentation, they have to pay for it. I think the same is true in the House bill that currently exists, is that if the employers, so any office visit or copay costs or something like that, the employer would be responsible for. I had one other thought that I just lost, but I'll kind of pause there because, as I mentioned, the goal is really to get to your questions. So I'm happy to try to lightning round it with Brad here and get to as many questions as we can.
Yeah, my guess is, Sean, whatever thought you lost, we're probably going to pick up during Q&A. We're loaded down with questions, so I am going to do my best to get as many as possible. I'm going to ask one first that I think you can answer pretty quickly. Are employers required to pay out earned sick time?
No.
When an employee leaves?
No, they are not.
So this is for everyone to know. This is not a benefit that you have to pay out. One question that came up that I think I'm not sure how well you can answer this because I know you to be a gracious person, but I also know that you have a job to do. How much grace do you expect as a department to give to employers who are making a good faith effort to comply on February 22nd or July 1st, knowing that there is still confusion? And, I can tell you, Sean, I've got like 200 questions in this chat that we're never going to get to, even, if I were to send them all to you by email by February 21st.
Yeah. So first and foremost, and Brad knows this quite a bit. So my job is I oversee my OSHA workers' comp, wage and hour, and the Bureau of Employment Relations. So all the regulatory stuff. And we really pride ourselves in trying to educate before we regulate, so to speak. So and one of the things we do in wage and hour in particular is we try to informally resolve issues. And we don't have any intent to go to employers that are making good faith effort, clerical error, miss something or anything else and try to lay down the hammer. We just want to work with you to correct the issue and move forward. So that's the way we look at it. That's the way we approach it. And then certainly we would work, to the extent that we can. You all understand we are the regulator, right? We have a job to do, but we definitely want to work with everybody to just make sure that it's working as well as it can. And we know there's going to be simple errors that can just easily be corrected.
All right, one other question that I think is really broad, and it's something that I've been thinking about. If an employer allows for unlimited PTO, and I know this is something that a lot of small businesses do, or whether it's a formal or informal policy, are they still required to accrue earned sick time under this act, or how are they supposed to treat that? Because under this instance, if you're sick or need to go to school, you're already, you're already
Yeah.
covered. How do we handle that?
Yeah, this is definitely one of the confusing things. So if we think about unlimited PTO or more than 72 hours that you're providing at the outset of the year, sort of we look at it like that front loading concept. But because there's no connection to accruals, we would encourage the employers to look at the end of the year ish and see how many hours Sean worked and if there's any hours to carry over. So it creates more of a challenge for employers, I think, that want to do that because to accurately, I mean, the employer could just simply ignore it and just every year just carry over a bunch of hours, call it earned sick time. But if they're trying to get it accurate, and we're not gonna worry if you just say we're just carrying over all this stuff and we're not paying attention to what the use was. But because there's no connection to that accrual, those employers are still going to want to evaluate at some point how many hours should have been carried over.
Yeah, and what I would point out to people in this situation is even as your employees accrue earned sick time, to the extent that you have a policy that doesn't require them to use it, and you never have to pay it out, it is an administrative
Yes.
task, but is not necessarily a financial burden on the company. Sean, we've got a number of questions about how we should handle temporary employees, internship programs, even a question about how we handle employees that we have in our household. And I don't know if that means like a cleaning crew or childcare. Can you talk a little bit about how we handle temporary employees?
Yep. Yep. Absolutely. So uh, try to draw a couple of distinctions here. So if somebody's a true independent contractor, so when we hear the word temporary employee, it gets confused a lot. It could be an independent contractor that's temporarily working with you, so they're not necessarily technically an employee, but we always call them that. When we hear the term temporary employee, we're actually thinking about the employer hired Sean for a limited period. So I am your employee. I'm on your payroll. I'm on everything else. So the distinction between the two is if I'm your employee, I'm covered and I accrue time. Now we know that there's a 90-day limit on use that employers can apply for new employees. So those workers will accrue time during that period, but they may not be able to use it. We're actually dealing with this question quite a bit in construction right now, where people change jobs more frequently, typically. You could have people that you're accruing time for that are never going to be able to access the benefits, but you'd have to log that and keep track of that. And then people in your home, it's the same question, Brad. It's, are they your employees? So you can have the IRS actually has a determination on babysitters that says they're not employees unless you meet some certain requirements. So that babysitter, probably not. If you have you're hiring some company to clean your house, they're not your employees, so that's not going to be your problem. If you've hired people, like I will never be one of these people because I'll never be able to afford it. But if I had a crew to take care of my grounds that are my employees, then they would be covered. But more than likely, you're hiring subcontractors or independent contractors, so you're not going to be on the hook for that. But if you're providing like workers' comp for them and you're doing W-2s and everything, they're more than likely they're your employee.
I know you don't have a grounds crew, Sean, but your driver is an employee, right? So I've got a question here from an employer who currently offers, at least 72 hours of PTO. What happens if that employer wants to continue to offer, 72 hours of PTO, but call it earned sick time? So, kind of say, we're not going to make you tell the lie and say, I have a cold, but I'm really at Disney World. How does is that allowable? And two, what are the limitations on that, if so?
Yeah, for sure. Yeah, the law specifically allows you to use existing vacation, PTO, whatever else. So you can fit earned sick time into that. And in some ways, it's modifying like a PTO policy to say, if you're limiting 72, at least 72 hours can be used for earned sick time purposes. So you can continue to do that, even though they can use some of that time for vacation. Now, importantly, if you do that, if I get 80 hours and you say 72 of those can be used for earned sick time, and I go to Bermuda for 80 hours, there is no earned sick time left. So there's not an issue there anymore because the employee used all of that available time for other purposes. So if they get sick, immediately after they come back from Bermuda and they want to use earned sick time, there's no hours there. Important distinction too, to that all of the provisions of earned sick time only apply to the hours that you've accrued for earned sick time. And if they're burned up through a joint sort of PTO plan, there are no earned sick time hours left there.
I think one thing, Sean, if you could clarify, I know this just from being part of the discussions as to how the chamber is going to implement this act. It's important to note that, if that any time you're going to count as earned sick time has to follow the guidelines of earned sick time under the act. So if you're going to, follow the scenario that Sean just laid out, you do have to allow them to carry over that 8 hours or 72 hours of earned sick time. Am I right?
Yeah.
Sean? So that may be an alteration that some people have to make to their PTO plans. What about so I've got a question in here about the small business exemption, and does it apply to employers who are employees who are just in state? So this might not. This is obviously a bad example because General Motors has way more than 50 employees, but obviously General Motors has employees, at the Renson and manufacturing facilities, but they also have manufacturing facilities in other states. So for the purposes of calculating whether you're a small business or not, does it just mean employees in state if you cross state lines?
For counting the number of employees, it's employees wherever they are.
Okay.
And I wouldn't say worldwide, but nationwide. And that's true on other statutes that we have that have employee sizes and all that kind of stuff. So General Motors would count for purposes of the 10 or more. They're going to count Michigan, Tennessee, whatever. Like they're going to count wherever they have folks. Conversely, though, it is only for work hours in Michigan. So none of those folks that an employer has somewhere else outside of Michigan are covered by this act or accruing by this act. But if you bring them here, they would be. The same is true if you're an employer out of Tennessee and you come to Michigan for some period of time, those employees would become covered by the Earned Sick Time Act. So count-wise, it's wherever they are. Hours, accruals, it's in Michigan. Work hours in Michigan.
And how about, there's another question that I think I gotta commend everyone who's on this call. You're asking questions that I've never even considered as someone who's been thinking about this for a long time. What about, the owners of a business or family members who might be on payroll? Do they count as employees? So, if I open a sub shop on the corner, and my wife and I are, obviously putting in a number of shifts, like a lot of these small businesses do. Do we count towards the employees?
Only if they've set themselves up as employees. So as I think everybody on the call knows, as soon as you set yourself up as a corporation, everybody becomes an employee, right? But if you're set up as like an LLC or sole proprietorship, just because you're working there does not mean you are an employee. So some LLCs, partners, whatever, they don't take a regular payroll. They're not doing all that kind of stuff, and they file their taxes differently. But if you set up your LLC and then like Sean's also an employee, and I'm doing the W-2s and I'm doing the federal tax withholding and everything else, I've established myself as an employee. Always remember that the entity itself and the individual are two separate things. So if you even if you're the owner and you set yourself up as an employee, you would be covered. Family members would be the same if they're getting paid. wages or salary, they're going to be considered an employee.
Um, Airline employees are typically fall under the Railway Labor Act. Obviously, they have different considerations. They're employed differently. Are they covered in this act? And
They
also, while you're thinking this way, I also have questions about employers with collective bargaining agreements.
Sure. So we have talked with the airlines. We're also hearing from the airline employees and the preemption. So we're working with them on the question. As it stands right now, our interpretation is yes, airline employees are covered. There is some case law on the West Coast that says yes. There's some case law on the East Coast that says no, but there's no like clear legal basis for the exemption. And the preemption we did find is not based on the Railway Labor Act. It's based on the Railway Unemployment Insurance Act. So there's a distinction there between the two. But we're continuing to have discussions and work with our legal counsel with both groups, and happy to do that. And then collective bargaining agreements, we do have a long FAQ posted on the application to collective bargaining agreements. We know there's two sections in ESTA, section 11 and 12, that both reference collective bargaining agreements. And section 11 says subject to section 12, and it gets a little bit convoluted. But the general gist in working with our legal counsel is the goal of the language is to not interfere with existing collective bargaining agreement language. So if you have an existing collective bargaining agreement that includes either provisions for earned sick time or an explicit statement saying employees are not entitled to earn sick time, then it would be with your next contract. So you still have to get up to date when you do your next contract. If your language is silent, like there's nothing in there about earned sick time, then it's applicable on February 21.
Okay, so here's a question. Again, I never would have thought of this, and this sounds like a great employer. At the end of each year, they pay out their unused PTO instead of accruing, instead of letting it accrue. Could they, under this act, would that be possible if they kind of used earned sick time as a replacement for PTO? Could they pay it out at the end of the year rather than rolling over the 72 hours?
Not as it's currently written. The employee
Okay.
would still be entitled to the bank. We have the same question. There's some provisions in there on if you're rehired within 6 months, you pick up whatever bank you left with. 6 months in a day, that bank is gone. But if you're rehired within 6 months, and similarly, a lot of employers like to just pay people out when they separate from employment. And then if they do bring them back, just start new. But the way the law is currently written, the employee is going to keep that bank and you could pay them out. But if they file a complaint, we're still going to be in a position where we basically have to find that they still have that bank. There's nothing that would allow us to draw that line.
So I also have a ton of questions about the provision that says you have to use, the smallest increment of time and allow employees to use that as their earned sick time act. Could you kind of address that? I mean, people are asking, our smallest increment is an hour, but then there's other people who are saying it's a matter of minutes. I can't imagine someone taking 6 minutes of earned sick time, but I know that's a potential fear, particularly for employees who are chronically late.
Yeah, the way the law is currently written, it is whatever you do for timekeeping. So if many employers through automated systems, frankly, do tenths of an hour. So that every 6 minutes is how it's counting once you punch in and all that kind of mumbo jumbo. So the way the law is currently written, it would be allowable for whatever increment that is. Now, if there's an employer that pays in 1 hour increments, they could do that. I'm not familiar with that. Many employers that do it that way. But it's whatever increment you're using to account for hours worked. So, for many employers, that would be 6 minutes, 15 minutes, something like that. So definitely something we're hearing a lot about.
All right. There's some questions about if an employee does a no-show, no-call for 72 hours, and the employer is required, or the employer asks them to get a doctor's note to say they were sick. What are the requirements of the employer there as far as paying for the doctor's appointment. Do you expect that to look for an employer?
If you've never dealt with FMLA, there's usually like a form you have to take back to your doctor. So I think what we would anticipate, this could be a little bit different, but what we would anticipate is you meet that 3-day threshold. The employer says you need to provide documentation on your need for the leave. The employee has to go back to their medical provider, whoever it was, that basically the reason they were off. And often that'll come with a copay or something like that. So that would be, and it could be an employer provided form too. But whatever thing they're trying to get from that provider, more than likely they'll get charged, because that's usually what happens with FMLA. And you have an office visit or a copay piece that has to be covered. I don't know if that covers that, Brad, but in essence, that's what we'd be likely to see.
Yeah, I know it is. It is. There's a lot of questions about it, and it's hard to get into specifics without drilling down into the about half dozen questions on this. Could you clarify how this works? I think I know the answer for salaried, but most importantly for commissioned employees. I wouldn't have thought about commissioned employees if you're in sales and you're not getting a salary. How do you calculate earned sick time?
It's the average of the week prior to when you use sick time. So for piece rate employees, solely commission employees, things like that, you would look at the week immediately preceding the time that they're using for earned sick time. So for commission folks, you could see some big variations, right? And kind of what that, and then that you basically calculate that into an hourly rate. For salaried employees, it's 40 hours. Or less. So MSU gave us a shout. They have some folks that are salaried at 20. So it'd be salaried at 20. Some employers, I just draw this, I don't know how many do this, but I've heard of it, is sort of, they call it a salary plus. So you're salaried at 40 hours, but if you put in X amount of extra hours, then you can get additional compensation. That gets a little more tricky because it is like you're counting hours, right? So I think when it's time for them to use that or accrue it, you would have to think about what that plus means. I would love to talk to people that do that, because I really haven't heard of it much, but it came up in one FAQ or one outreach event we did on kind of how you actually do that. But generally salary, it's 40 hours, even though they're putting in 50, 60, whatever, it's 40 hours.
So Sean, I don't know if you know the answer to this question, and I apologize. We've only got a few minutes left. But this will be the last question I ask you, and then I'll get to a few of the questions that showed up in the chat about the status of House Bill 4002. Is that there's been talk, I know politically, about if we can't find a compromise on the policy yet, moving the implementation back from February 21st to, whether it's July 1st or December 1st. Various times to give the legislature more time to work on this. What I have heard, kind of in the halls of the Capitol, is there may be some structural reasons within the act that would be difficult. Do you have insight onto that and why that may be a challenge? And if you don't know the answer, that's fine. But
no, I wouldn't see that in the earned sick time. I think the minimum wage piece has more like specific dates, right, on when things happen, where you could see some more difficulty. I think in the Earned Sick Time Act, I don't think there's any specific references to dates other than April 1, which was in the original one, kind of the court modified for certain notice pieces. But I've not heard that myself, Brad, and I've not been asked about any kind of structural challenges with that.
John, is there anyone, I know you shared the website, michigan.gov/Earned Sick Time Act. Is that the right website for people to go to? Is there anyone else that they should reach out to with specific questions, or are there contacts on there in the event that we're not able to get to everyone today? Like I said, we're tracking these questions and we will do our best to get as many answers as possible that we weren't able to get to today. But is there more resources for people who Sean?
Yep. We have a really big and long FAQ on there, so I'd encourage you always to check that out. And we worked with Brad and the other chambers and business groups on kind of get us all these questions, and we tried to incorporate as many as we can. We know it's in government gobbledygook, so it's a little bit confusing. But if you go to our Michigan Wage and Hour site, that's the same site as the Earned Sick Time Act. There is an email address. It's whinfo@michigan.gov. You can find the link right on there. You can submit questions on there. We get a ton of them, and we do work to respond to those. There's only a couple of people that do that, and we got, you can imagine, thousands of questions. So they are working through that as quickly as they can, but you can certainly continue to ask questions there. And Brad knows how to find me, so I'm always happy to work with Brad as well on kind of getting info back.
Sean, I can't tell you how much I appreciate your time today. I know it was incredibly valuable. We had over 500 people join us today, which is amazing. I want to there was a number of questions in the chat about the status of House Bill 4002 and kind of the legislative back and forth. And I will share that with you before we log off and say goodbye for today. House Bill 4002 was introduced by Speaker Matt Hall and the House Republicans as their first act when they took over the majority at the first part of this month. They appointed a special committee to move the bill through the process and moved it through the process very quickly. And now it sits in the state Senate for the Majority Leader, Winnie Brinks, and the rest of the state Senate to send it back to the House. I think the Senate also introduced a bill, which is Senate Bill 15, which considers some of the provisions that we talked about earlier, some of the 5 things that we'd like to change. Not all of them, so it's an imperfect vessel, but the fact that they have introduced it is a good thing because it gives us an opportunity to negotiate. We've engaged with the sponsor of that bill, Senator Sam Singh, and sent some amendments over to him that we think would take this bill and make it the best bill possible for our members. So with that, I would encourage everyone again on this call to go to senate.michigan.gov and look up your state senator. If you don't already know who that is, send them an email, let them know how important it is to pass Senate Bill 4002 as quickly as possible. I promise you, it will make an impact. When state legislators meet with their staff and do their staff meeting, their staff will go through and say, Senator, we got 20 emails on Earned Sick Time Act, or we got 5 emails on transportation funding. They may not read every single email individually, but they will hear your voice. And so reaching out to them and letting them know your pain points and the importance of getting this fixed before February 21st, I can't tell you enough how important that is. And if there are, if there are questions that you have, of course, Sean gave you the best resource, but we here at the Chamber are here to serve you, whether you're a member of ours or not. We want to make the business community as successful as possible and allow for your growth. So with that, I will thank you all for your time and wish you a good weekend. And hopefully you're not going to spend your whole weekend trying to figure out your earned sick time policy. Hopefully you get some time to enjoy a nice February weekend. So thank you so much, and we'll talk to you soon.